All right, good afternoon, everyone, and welcome to the Maryland State Commission on Criminal Sentencing Policies, which we commonly refer to as the MSCCSP, our quick Q&A session for law clerks and court staff. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland Sentencing Commission. Some of you might recall that we held 2 law clerk and court staff orientation sessions back in September, as a lot of new law clerks had onboarded at that time. So now that a few weeks have passed and some of the newer law clerks and court staff are hopefully more familiar with the sentencing guidelines and our Maryland automated guidelines system, we thought it'd be helpful to follow up with a quick question and answer session. This gives you all an opportunity to ask any questions and receive answers from our staff in real time. So with that said, several of my colleagues are here with me today. Our Executive Director, David Soule, our Program Analyst, Sarah Bowles, and our Research Analyst, Kathy Sanchez. To get us started and a little warmed up, we have compiled some of the more commonly asked guidelines and MAGS-related questions from law clerks and court staff. So these questions that we will be reviewing will cover a range of topics, including sentencing guidelines eligibility, what constitutes a guidelines compliant sentence, and then some of the more frequently asked questions relating to MAGs. Now, even though we already have some questions to review, if we get to a topic that may be relevant to any question that you have, please feel free to raise your hand in the Zoom panel. We can then call your name. You can feel free to unmute yourself and ask your question. Or alternatively, you can submit any questions that you have through our chat box, and our staff will reply to you. Now, we do encourage you to submit your question to the entire group, just so everyone can benefit from seeing the question as well as the answer. But that said, if you don't feel comfortable submitting your question to the entire group through the chat box, you can just send a message directly to either David Soule, Sarah Bowles, or Kathy Sanchez. So to get started, let's look at a common question regarding guidelines eligibility. The question is, do Maryland sentencing guidelines apply to misdemeanors? Now, this is a question we've actually been receiving with more and more frequency, really throughout the last couple of months. And the answer here is yes. So to clarify, the sentencing guidelines apply to guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. So they are not solely limited to felonies that are prosecuted in a circuit court. So let's take a look at the broader scope of the sentencing guidelines here. So as I just mentioned, the Maryland sentencing guidelines apply to criminal cases that are prosecuted in a circuit court. The sentencing matters that you see on the left-hand side here require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So these include circuit court original sentencings, jury trial prayers and appeals from the district court if a pre-sentence investigation is ordered, and original sentencings adjudicated via a probation before judgment. Now, in addition to original sentencings, given concerns involving crimes of violence, we also collect worksheets for reconsiderations and modifications and 3-judge panel reviews involving a crime of violence as defined under Criminal Law 14-101 if there is an adjustment made to the original active sentence as a result of that modification. Guidelines eligible reconsiderations and modifications, they include adjustments imposed pursuant to Maryland Rule 4-345, a Health General 8-507 order, or again, a 3-judge panel review. Now, the sentencing matters that you see on the right-hand side, these are also handled by judges in a circuit court, but they are excluded from guidelines coverage. So those include jury trial prayers and appeals with no PSI, if the offense carries no possibility of incarceration, violations of public local laws or municipal ordinances, sentencing hearings in response to a probation violation, criminal non-support and criminal contempt cases, juvenile court adjudications, and then finally, the guidelines do not apply to district court sentences. Now, we often get guidelines eligibility questions regarding 2 offenses in particular. The first is a violation of Baltimore City Code 59-2. It's a discharging firearm offense. Now, even though this offense does carry the possibility of incarceration, it is a violation of Baltimore City Code and therefore is not guidelines eligible, meaning that it wouldn't be reflected on the guidelines worksheet. The second offense is reckless driving. So this may often be charged with other motor vehicle related offenses, But since this offense does not carry the possibility of incarceration, it would also be excluded from the guidelines worksheet. Here's another question regarding guidelines eligibility. If the Appellate Court of Maryland has remanded a criminal case back to the respective circuit court for resentencing, is a sentencing guidelines worksheet required? The answer is no. So a guidelines worksheet would not be required if the Appellate Court of Maryland remanded a case back for resentencing. Now, as a reminder, in addition to original sentencings, we collect worksheets for reconsiderations and modifications and 3-judge panel reviews when an adjustment is made to the active original sentence and the case involves a crime of violence. An appellate court remanding a case back to the respective circuit court for resentencing is a different type of sentencing matter than that of a reconsideration modification or 3-judge panel review. So this is why a guidelines worksheet would not be required in this scenario. But one last note, if the appellate court was remanding a case back for a new trial, then we would require a worksheet for the new trial. Now, I do just want to note that the Sentencing Commission worked with JIS to identify guidelines eligible cases requiring a worksheet in MDEC counties. So here's a screenshot of what a criminal docket would look like generated through MDEC. And you can see that the guidelines eligible cases here, they're marked with this MAGS yes indicator. So I did just want to point out that we do have this guidelines eligible case indicator based on feedback that we have received from law clerks and other court staff, even state's attorneys. They have found this case indicator to be helpful. That way they can look to this docket and see which upcoming cases require a sentencing guidelines worksheet. So I did just want to point this indicator out to you if you do think it would be helpful to reference. All right, so here's a common question that we receive regarding guidelines compliance. Now, why is MAGS flagging the total overall sentence as a departure from the guidelines? And the answer is that the total overall sentence is not a guidelines compliant sentence. So let's review what constitutes a guidelines compliant sentence. A sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, falls within the applicable guidelines range. So I do want to note that generally suspended time is not considered when determining if a sentence is compliant. There's one exception involving corrections options, which we'll talk about in a moment here. But again, generally suspended time is not considered. It's that sum of incarceration, credited time, and home detention time that's used to determine guidelines compliance. I also want to note that compliance is calculated by comparing the overall sentence across all convicted offenses in a sentencing event to the overall guidelines range for a sentencing event. So, for example, it's possible that the sentence could exceed the upper guidelines limit for one offense in a sentencing event, fall below the lower guidelines limit for a second offense, but the overall sentence, when adding together the sentences for both counts, it can still fall within that overall guidelines range for the sentencing event. That's also taking into consideration whether the sentences are running concurrently or consecutively to one another. Now, there are a few qualifiers to consider regarding guidelines compliance. The first is that sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. Now, binding pleas are 3-party agreements in which the defense and the state present to the court on the record an agreement that incorporates a specific sentence. Effective April 1 of 2021, the MSCCSP narrowed the definition of what constitutes a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and the agreement becomes binding on the court under Maryland Rule 4-243, subsection C, if the court accepts the plea. So let's take all of that information and we're going to apply it to a couple of hypothetical sentencing scenarios. Let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? And the answer is no. So as a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, and not merely a sentence range or cap. So in this scenario, the court accepted a plea agreement to a sentence range, anywhere from probation to 2 years. So this is why it would not constitute an MSCCSP binding plea agreement. Let's look at sentencing scenario number 2. Let's say the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended, with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended, with credit for 62 days. Is this an MSCCSP binding plea agreement? The answer here is yes. So in this scenario, there was an agreement to a specific amount of active time, that being 0, or in other words, no post-sentence incarceration. Therefore, this would constitute an MSCCSP binding plea agreement. Now, an additional qualifier regarding guidelines compliance to consider is the role of corrections options. Now, sentences to corrections options programs, for example, drug court, residential substance abuse treatment, home detention, they are deemed compliant provided that the initial sentence plus any suspended sentence, so essentially the total sentence, if it falls within or above the applicable guidelines range and the case does not include a crime of violence, child sex abuse, or escape. So this is the one exception I mentioned earlier in which suspended time is considered for determining a guidelines compliant sentence. Now, corrections options allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. Corrections options include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under Health General 8-505 or 8-507 order, drug court, participation in any problem-solving court, a sentence with required substance abuse treatment for the possession of controlled dangerous substances, work release, or weekend or other discontinuous incarceration. Now, here's a question relating to guidelines compliance and the use of corrections options programs. Do I need to mark a corrections option program, for example, drug court, if the defendant successfully completed the program prior to sentencing in their respective case? So the answer is yes. Pre-sentence participation in drug court or any other problem-solving court should be reflected in MAGs. So in some jurisdictions, defendants can go through the entire, for example, drug court process before they're formally sentenced. So in that case, even though there was pre-sentence participation in a corrections option program, that being drug court, it is something that we would still want to be reflected in MAGs and should factor into guidelines compliance. So you do want to mark pre-sentence participation accordingly. So here's sentencing scenario number 3, a scenario involving the use of a corrections option program. Let's say the overall guidelines range for the sentencing event is 1 year to 3 years. The defendant was sentenced to a 6-year total sentence, all of which is suspended. The defendant was also sentenced to drug court, a corrections option program, as defined under commission criteria. Which of the following best describes the sentence imposed? Is this a departure below the guidelines, a departure above the guidelines, or a guidelines compliant sentence? The answer here is that it is a guidelines compliant sentence. So as previously noted, sentences to corrections options programs are compliant provided that the initial sentence plus any suspended sentence falls within or above the applicable guidelines range, and the case does not involve a crime of violence, child sex abuse, or escape. So in this case, even though the sentencing event, the guidelines are 1 year to 3 years, Given that this defendant was sentenced to a 6-year total sentence, even though all of it was suspended, it falls within or above that overall guidelines range of 1 year to 3 years. And the defendant was also sentenced to drug court, a corrections option program. This is what makes it a guidelines compliant sentence. Now, the last rule regarding the calculation of guidelines compliance is that sentences in which the offender received credit for time served with no post-sentence incarceration time, and if the amount of credited time exceeds the guidelines range, it's deemed guidelines compliant. So, for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence is still guidelines compliant, even though the credited time exceeds the upper guidelines limit. And MAGS is programmed to account for this. So since you all play such an important role in the guidelines worksheet completion process, I do want to review some of the more commonly and frequently asked questions that we receive that are related to MAGS, our Maryland Automated Guidelines System. So I'm going to log into MAGS in a moment here, and we will quickly review the following. How to identify multiple criminal event, single sentencing event scenarios, how to delete merged or null pros offenses, how to account for credit for time served when there are consecutive sentences, and then how to view a submitted worksheet. So if you can just give me a minute here, I'm going to go ahead and pull up MAGS. Okay, so here I am on my home screen here. Quickly log in. Okay, so after logging in, I'm brought to my home screen here where I'm going to search for some previously initiated test cases that I created here. So I'm going to go ahead and filter by Prince George's County, which is the jurisdiction, and then I'm going to go ahead and search for my test case here, that being John Smith. So you can see after I search for that particular defendant, I can see that 2 cases numbers are populating here, one ending in 111, one ending in 1133. And I can see that they have the same sentencing date of 11/3/2023. Now, when there are multiple cases sentenced in front of the same judge on the same day, that means that they constitute one sentencing event. And when these worksheets are initiated in MAGS, the worksheets for those unique case numbers, they should be initiated under one MAGS record and therefore share the same worksheet ID number. Now, there's 2 primary reasons why that is important. One, they need to be combined under one MAGS record to ensure proper calculation of the overall guidelines range. And 2, it's to avoid any issues when you get to the point of submitting the worksheets. So in this case, again, these are 2 cases that are being sentenced together on November 3rd of 2023. So they correctly share the same worksheet ID number of 149441. Now let's say that these 2 cases, even though they are a part of the same sentencing event, they were initiated separately, meaning that they would have 2 different worksheet ID numbers. What would happen is you'd be able to enter all of that sentence information. You'd be able to successfully submit the worksheet for the first case. But upon attempting to submit the second worksheet, you'll get a duplicate error message saying that a worksheet with the same SID number, date of birth, and date of sentence has already been submitted. You'll have to contact our office, and then we have to combine them for you and send you back a revised PDF. So again, I do just want to point out this worksheet ID field as it's an important field to pay attention to. If you do notice in this type of scenario, if you noticed that these 2 worksheets had different worksheet ID numbers, but you know that they need to be combined, we do encourage you to reach out to the state's attorney and ask them to combine the worksheets for you prior to entering any sentence information. One, it's just a good reminder for them moving forward that they know that they need to combine them under one MAGS record or worksheet ID. And 2, it just eliminates any issues for you all when you go to submit the worksheets. So I'm going to go ahead and click on the edit icon here. I'm going to jump to the list of offenses tab. Now, any merged or null pros offense should be removed from the guidelines worksheet. It should not be reflected or count towards the overall guidelines calculation in any way. It should be removed. Now, ideally, the state's attorney is going in and deleting these offenses for you prior to you getting into MAGS and entering the sentence information. That doesn't always happen in a timely manner, so I do just want to point out that it's a really quick and easy step that you all can take to delete those offenses from MAGS, and then you can proceed with entering sentence information and ultimately submitting the worksheet. So from here on the list of offenses tab, let's just say this felony theft count ended up being merged with the burglary first degree. So to delete this offense, I just simply need to click the little trash can icon. It's going to ask you to confirm that you want to delete it, and you would simply click OK and then save this page. Now, if deleting an offense happened to adjust the overall guidelines range calculation, not to worry, MAGS would automatically update that for you. But just to note, the lesser offenses tend to be the ones that are merged, merged or null pros, so it normally doesn't factor into overall guidelines calculation. Okay. So moving forward to sentence information here. So here's where we obviously enter the individual sentence information, and I want to quickly discuss how to account for credit for time served when you have consecutive sentences. Now, just to keep this simple, I just went ahead and clicked on the edit icon for assault second degree. I entered the same offense for both offenses. So this is a 10-year suspend all but 65-day credit for time served sentence that was imposed for both of these counts. So you can see here, I have the 10 years, suspend all but the 65 days credit, and I flagged this as being consecutive to another count in the sentencing event. I'm going to quickly bring up the first burglary first degree so you can see that I did the exact same for this offense too. Now, in this case, I just want a total overall amount of credit to be reflected as 65 days. However, since I entered that 65 days credit in for both of those sentences and they're flagged as running consecutively, you can see here when I get to the GLS overall sentence tab, MAGS added that credit together. So if you were to enter credit for time served into sentences and several of them were running consecutively to one another, MAGS adds that credit for time served across all offenses that are flagged as running consecutively. So when you have a sentencing event that involves multiple sentences, some or all of which are running consecutively, you only want to reflect that credit for time served for one of those offenses. So if I were to quickly jump back here, and let's just say, I'm going to delete all this. I'm going to make this one a 10-year fully suspended sentence, and I'm going to zero out the credit here. If I were to click Save this page now and then jump to the GLS overall sentence tab, we can see that this is now properly reflecting the 65 days credit for time served. Now, one more thing I just want to quickly note while I'm in MAGS, since we were talking about guidelines compliance earlier and what constitutes a guidelines compliant sentence, I just want to show you how MAGS accounts for that. So in this case, if we're looking at the overall total sentence, we mentioned earlier how generally it's the sum of incarceration, credited time, and home detention time that's used to determine guidelines compliance. So in this case, I can see the sum of credit for time served, with 0 home detention and 0 jail prison moving forward. The guidelines applicable sentence is essentially that 65 days credit for time served, which falls below that overall guidelines range of 6 months to 5 years. However, we also talked about how any sentence adjudicated pursuant to an MSCCSP binding plea agreement is deemed compliant. So if I were to jump to this departure and submit tab, you can see that this is saying that it's not a departure from the guidelines due to the fact that it was adjudicated via an MSCCSP binding plea agreement. Now, next to this, I can also see in red text that it's saying it's not a departure due to the use of a corrections option program. So if I were to jump to this alternatives to incarceration tab, you can see that I also marked that drug court was utilized, which is a corrections option program. Now, jumping back to the GLS overall sentence tab, we talked about when a corrections option program is utilized, as long as that total sentence falls within or above the applicable guidelines range and the case doesn't include a crime of violence, child sex abuse, or escape, it would be deemed compliant. So in this case, that 20-year total sentence falls within or above the overall guidelines of 6 months to 5 years. And again, given the use of drug court here, that's why MAGS is saying this is not a departure because the corrections option program was utilized. So that was just something I wanted to show you while we were in MAGS. So the last step I want to show you, I'm actually going to quickly go ahead and submit these worksheets here. And I get confirmation that it was successfully submitted. I'm going to go back to the home screen real quick. Now, judges and their designees, you all have read-only access to submitted worksheets. And a lot of you are actually surprised to hear that. If you call and you're wondering if you're able to view a copy of the submitted worksheet, you're surprised to know that you do actually have the ability to do so in MAGS. So I want to quickly show you how you would do that. So here we just saw that I went ahead and submitted my case. Now to view the submitted worksheet, I would go ahead and again, filter by jurisdiction. Jumping down under the worksheet ID field, there's this box here that says include submitted worksheets. If I check that box and then were to search for my case, you can see here that those two cases that I submitted here ending in 11 and 1133, there's a little check mark showing that they were submitted. Now, I'm part of MSCCSP staff, so I do have editing capabilities for submitted worksheets, but you all would simply see this little Adobe icon allowing you to view the submitted worksheet. So that kind of wraps up those frequently asked questions pertaining to MAGS. Are there any questions while I'm still in the MAGS system? Okay, I don't see any here, so I'm going to quickly pull up the last slide. Give me 1 second here. Okay, so that really wraps up like our quick Q&A session. If you ever have questions or feedback regarding the sentencing guidelines, the work of the Sentencing Commission, or anything that may be MAGS related, please always feel free to contact us either over the phone at 301-403-4165 or via email at msccsp@umd.edu. So that said, I'll just ask one more time if there are any outstanding questions, anything that we want to address before we conclude here. Okay. I don't see anything coming through. So again, if you ever have a question, any feedback, always feel free to contact us. Thank you so much for attending this afternoon. I hope you found this to be informative and helpful, and I hope you enjoy the rest of your day. Thanks so much.